like to start these presentations with a quote from my mentor, Art Nazaro, and he said, "Get the deal done, but protect your client's interests." Now, this is somewhat like a Zen koan to me. I just kept saying, well, what does it mean? How do you balance it? And it's something that today I still consider every time a new deal comes across my desk. How can I get the deal done, and how can I protect my client's interests? So, now, with that as the goal, how do you achieve that? And really what you need to do is you need to look at potential pitfalls, because if you do not know where you're going, what the problems are going to be, there's no way for you to protect yourself against those problems. So once you've identified these potential problems, what I would suggest to you is the next step is to have an arsenal of savvy solutions that you can use to get around all of the obstacles, to protect your client's interests, and to get the deal done. So today we're going to go over really 4 pitfalls. And there's going to be 2 pitfalls that we're going to look at in the context of a purchase contract, and 2 that we're going to look at in the context of lease letters of intent. Purchase contracts. I placed this image of a clock and a calendar in the slide right beside me, because we're going to be looking at time is of the essence. Now, I know this is not a provision that you consider often. Okay, I realize that. But we're going to look at this provision once from the buyer's perspective and once from the seller's perspective. So let's look at what the Colorado contract actually provides. Section 21 of the purchase contract says, time is of the essence for all dates and deadlines in this contract. This means that all dates and deadlines are strict and absolute. Now, this underlying provision is what's been added to the 2016 form. And what it really means is that time is the essence, we're serious about it, and there is going to be no exceptions. Okay? That's the basis, the baseline for the form. So let's talk first now about a buyer's perspective on the time is of the essence provision. As you know, in all instances of purchase contract, there's an earnest money requirement. It's generally payable to the title company, and it's due a few days after the contract is signed. So now what happens if the deposit is a day late? FedEx gets delayed. The wire transfer doesn't work. Or, God forbid, the buyer forgets and brings it in to the title company a day late. Well, in all of those instances, no matter what the reason, the deadline has been missed. So, at that point, the buyer's in default, and now with this double-down, serious times of the essence provision in the contract, we know that the buyer's in default. So what remedies are available under the contract? This is section 21.1.2. It says, seller may cancel this contract. All earnest money, whether or not paid, will be paid to the seller and retained by the seller. This, I think we can all agree, is a very, very stiff penalty. Whoa, 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 is some of the comments that are coming from the audience. So, what might happen if this day late scenario occurs? Well, the seller may walk. I think litigation will follow. And what's going to happen to the broker's commission? And I'm sorry about this. Not going to earn money. So now that we have this potential pitfall that we know about, we're aware of in the contract, what can we do? How can we look back and create a solution that will protect the buyer's interest in this case? Well, I like to look now to not the purchase contract or purchase contract concept, but rather to a lease, a commercial lease. So what provision that is applicable to this discussion is in every lease, and that is a notice and cure period. So before a landlord or a tenant can be in default, a notice has to be given, time has to lapse, and then the default occurs if it's not cured from that time period. So let's look at what a notice and cure period provision might be in a purchase contract. And for purposes of this presentation, this is a very short kind of dumbed-down provision, but it will serve for our purposes of illuminating our discussion. It says, if a party does not cure a default within 3 business days following the delivery of written notice, that party shall be in default. So if this clause was included in the contract that we just discussed, where the deposit was a day late, what would happen? Well, the deal would close. You know why? Because 1 day late, there would be no harm, no foul, no notice would be given, and the transaction would move forward. We're now going to look at the second default. And this is seller's perspective on the times of the essence provision. In a situation that occurred about 3 years ago, there was a seller who was selling a building. It was a $2 million building. And he was represented by a broker, and they both showed up at the closing table on the closing day. The seller, while owning a large building and being successful, wasn't really sophisticated in real estate. So when he arrived at the closing table, he said, I didn't see this document, I didn't see that document, the prorations are off by about $8,000 or $10,000, I don't understand this, and it couldn't be resolved, so I'm not in a position to close right now. So they didn't close that day. He went back to his home state, and for the next few days, the buyer, the brokers, and the seller were trying to resolve the issues to come up with a solution to close. And then, what happened next is that the buyer sent what I will call a passive-aggressive letter. And this is what the letter looks like. One option for me at this point is to pursue legal avenues such as damages, specific performance, attorney's fees, etc. This is not a road I want to go down, but, and what do you think that means? What's the ellipsis after that? How's the sentence go? Well, the sentence goes, you're a default, I have you over a barrel, and I'm going to make your life miserable. And that's what proceeded to happen. So what happened is, at that point, the seller realized this is serious, and we need counsel. So he retained me. I looked over the contract, I looked over this demand letter, and I had to be the bearer of bad news at that point. I said that with this threat of this pendants hanging over your head, you can't sell the property to a third party. Because if you enter a new contract with somebody, and then the list pendants is filed, you'll be in default of the new contract, and you'll be in default of the old contract as well. And that wouldn't be a good situation. So I told him, you have to work it out. You have to work it out with this buyer. And this buyer was savvy, and he knew how to work things. And it took over 3 months to get this buyer satisfied and for the transaction to close with a substantial discount to the purchase price. This was not a good outcome for the seller. So now, looking back, knowing what this pitfall is in the transaction, what can the seller do? What are some solutions that we can craft for the seller to protect this potential problem? And the seller's solutions first would be the notice and cure period that we discussed previously. This notice and cure period, again, requires notice and then a lapse of time for 3 days before there's default. And in this scenario, if that provision were included in the contract, what would have happened? Well, they would have continued the discussions the following days about how to resolve things. And then if the buyer really got serious about calling default, the buyer would have served a 3-day notice. And I think in that instance, what would have happened is that at that point, the seller would have been snapped to alert and would have said, wow, this is serious. At that point in time, he would have brought in counsel and he would have resolved the issue at that point and closed within the 3-day period. The next provision that we can think of how to protect the seller in this circumstance is limiting the buyer's remedies. Now, by this I mean a clause similar to this. Buyers shall not have the right to file a lawsuit for specific performance after the 30th day following the closing date. So what this means is this buyer must file a lawsuit within 30 days, otherwise they waive the right to file a lawsuit for specific performance. If the lawsuit is not filed within 30 days, then the seller is free to sell the property to a third party. And if it is filed within 30 days, then what would happen? Well, the seller would be in no worse shape. They'd still have a dispute to resolve with the buyer. And in my experience, when this clause is in place and there's a dispute, that second timeline motivates the people to come to resolution within that time period, because it's still a big step for a buyer to file a lawsuit. So it motivates settlement. So I think that in that instance, and I put these provisions in contracts when I represent sellers, the deal would close. It would either close within maybe 7 days after the original closing date or 30 days after the original closing date. Now, let's look at lease letters of intent. First, I said this last year, and I'll say it again. Although I have a vested interest in the outcome of the discussions about whether or not brokers should be permitted to draft and negotiate letters of intent, I firmly come down on the side of brokers doing this. I think it makes sense, and I think that the only provision that needs to be in place in the letter of intent that we draft is a well-crafted, non-binding provision. And the provision that Alan spoke of earlier, to me, was an example of a provision that was not well-crafted. And if you go to my website, or if you give me your card after this presentation today, I'll either send you, you can find a link to my website to an article that says, here are the 8 steps you need to take to make sure that letters of intent are not binding. So, having said that brokers should prepare letters of intent, there are some times where I think there's exceptions. And you might want to have an attorney on your team early on in the process. What are those reasons? I'll give you 4 examples. The first is you're dealing with a situation where there's an attorney on the other side. The second is you're dealing with a letter of intent that's very detailed, and you've really gone beyond your comfort zone. Third might be a large transaction, big deal, where it makes sense to have another pair of eyes on the documents early on, so you can anticipate those potential pitfalls and put solutions in the letter of intent. And lastly is a situation where there's unequal bargaining power, where there's an underdog, and you're representing the underdog. You might want to have an attorney on your side, for example, in a situation where an individual is going up against a large corporation. Now we're going to shift to the pitfalls. There's 2 more pitfalls, pitfall 3 and 4. And I chose these pitfalls from among many that I could have chosen because really they interest me, and they're 2 matters that came across my desk within the last 6 months. So the first pitfall is expenses and repairs. What happens? Well, this is a typical provision, actually pulled from a letter of intent, that says tenant will pay all operating costs, taxes, and insurance expenses. I must say, I think this provision works well. And in most instances, I leave it in if I'm asked to review a letter of intent and don't make any modifications. But it doesn't always work well. So let me tell you a story that applies to this. I had a client that, well, not a client, but he started the process of negotiating a deal for a lease of his entire building to a large corporation. And he was working with a broker, and they negotiated the terms of the deal, basic outlines of the term. And then it went to a large corporation to prepare a letter of intent, the offer. And what came to the owner, to the potential landlord, was a detailed 5-page letter of intent. And so there was a lot in there. At that point, the broker and the owner decided it was a good idea to bring counsel in. They brought me in, we looked over everything. And at the first meeting, we sat down and we talked about it. You know, you talk about life, talk about things. And the owner, really nice, lovely gentleman, says, you know, I've had a good run at it. I've operated my business in this building for 25 years. I'm looking forward to retirement. I'm looking forward to traveling with my wife and spending more time with my kids. And he said, I just really want to cash checks. I don't want anything else. I put it to you that under that circumstance, with those goals in mind, this provision that's up on the screen does not work well in that scenario. So how do you protect the client in that? How do you get to achieve the goals of that client at that point? Well, this is the clause that we ended up negotiating and putting into the letter of intent. it is intended that this lease will be a net bond lease. And that basically means you're just collecting rent checks, with tenant being responsible for the maintenance, the repair, the replacement, and the rebuilding of the premises. This is basically a summary definition of what a bond lease is. And this made it in the letter of intent. So let's look back and say, well, what would have happened if this clause did not make it into the letter of intent? What if it wasn't negotiated? So I think what would have happened, and I know you well what would have happened, is that the letter of intent would have gone up to in-house counsel. In-house counsel would have looked at the letter of intent. The form that would be created by the counsel for the tenant would have standard provisions about operating expenses. It would have certain provisions for the landlord to repair and maintain the property. Damage and destruction provisions, it would require the owner to rebuild. So there would be a lot of provisions that would be different. Now, what would happen at that point when the lease was received? Well, either three possibilities. The owner would cave, but then his intentions and desires would have been represented. The second is that we would have had protracted negotiations, would have taken a long time to turn that around and write it to what the owner intended. And lastly, what would happen is the deal would have. So now, I'd like to go to pitfall number 4, which is the fair value option. And this is really a fair market rent option. And I'll give you an example of a clause that I see often in letters of intent, and it goes like this. The base rent for the option period shall be the fair market rent. You're laughing. And again, if I'm coming up in certain situations, and this is the letter of intent I'm asked to review it, I might not make any changes to that. If it is a situation where I'm representing the landlord, that's a good provision for the landlord. If I'm representing a tenant with a lot of negotiating power, I'm not really concerned because the details of what fair market rent means will be worked out when the lease comes. But let me share a story of a recent transaction where a client came in, and it was a smaller tenant, and they were doing a lease with a REIT, very powerful, big corporation. And this tenant had an interesting business, and it was a low-margin business, so cost was a big factor. And the location they were going into was really important to them. So the option was a material factor, material importance for this tenant. So it wouldn't make sense to leave this provision in because with the unequal bargaining power when the lease came, it wouldn't be great negotiating position. So we were able to put into the letter of intent the following provision. The base rent shall be the fair market rent, taking into account free rent, tenant improvements or allowances, and other market concessions, if any. So what happens? Now, when the tenant exercises the option, instead of paying, let's say, for example, $20 per square foot as a stated rate of the rent, taking into account those concessions, the rent might be $18 per square foot. So this is a provision that helped the tenant achieve its goals, prevented a potential problem in the negotiations of the lease, and moved the transaction forward. Here's my closing slide. And what we've been discussing here really is the need for striving for balance. When you're a real estate transaction professional, you really have to strive for balance between protecting the client's interests and getting the deal done. So now I'd like to open it up to your questions, discussions with the panel. I think that the point about having a cure period is really appropriate, and I think the way I look at it, in terms of doing everything I can to deal with potential pitfalls up front so that deals actually get closed, I think that this clause of noticing a cure period makes a lot of sense. And let me tell you, because it hasn't been asked and I anticipated, it's a question that I often get. Well, how does this clause relate to title objections, resolutions, etc.? And the answer is, it doesn't impact those provisions. Those are different than the default provisions of the contract. So I'm not saying that this is going to apply to title notice, inspection objections, etc. It doesn't. It only applies to defaults under the doc. Another issue that comes up is, well, should there be any exceptions to this provision about notice of cure? And I think maybe there should be, depending on the timing and particular circumstances of the transaction. One might be the party of the transaction is in a 1031 exchange, and there's an absolute deadline, and the tax exchange would be blown if, in fact, there's a 3-day extension. There might be circumstances where there is a loan that has a deadline, it has to fund by a certain deadline, and if missed, the loan would go away. That might be an exception that you want to draft into the provision for your contract. It's always a pleasure being here. Thank you very much. And you can come up to me afterwards to ask questions just out of time. Thank you.